Greetings, my fellow Americans, and welcome to another episode of the Great Montana Conspiracy Podcast. I am your host, Ron Glick. Now, tonight I'm going to be touching on a bit of what I talked about in the last episode, more so because it's a subject that came up in the last episode that I realized I really haven't dealt with, and that's the Prison Litigation Reform Act. But before I get started talking about that too much, remember, please hit your like and subscribe button. Go down to the area below the video, beside the video, whatever platform you happen to be watching on. Like, subscribe, and share this video with your friends and family. Post it to other social media, Facebook, Twitter, wherever you think this might get some exposure. Remember, the more people that listen, the more people that hear this information, the better we chance of affecting change. As always, if you are watching this video and for some reason it does not have the text attached to it, you can feel free to visit this podcast either on YouTube, the Great Montana Conspiracy Podcast, or you can go to monspiracy.podbean.com, which is where this podcast originates, to make sure you get the appropriate text that's attached to this video. Now, in the last episode, I spent over an hour and a half talking about Angela Townsend, specifically talking about how she stole a trademark from me, the Forlorned, and then has spent the last several years using every opportunity to try to shut down my social media presence, my presence on the internet, any vehicle by which I can use to basically challenge what she's done. And a lot of times people will say, well, go to court, file a trademark suit. I did file a trademark suit, and that's what I'm going to be talking about today. Because I realized I went over so much. I literally took an hour and 37 minutes to talk last time, which is the longest podcast I've ever done, and I amazed myself that I got through it without breaking up. The only break was actually when the battery on my recorder died and I had to replace it. So as you can understand, there was a lot of information, but for all the information I relayed, there is still so much more I did not get into that podcast. I literally had to pick and choose what topics to bring up, which ones to delve into, which ones not to. And in hindsight, I realized that I really needed to cover the trademark lawsuit because I just brushed over it. I touched on how the U.S. District Court changed the facts in order to deny my claim, but I didn't really offer the details. And the reason I chose to pass over it was because of what I talked about at the beginning of this podcast, which is the Prison Litigation Reform Act. In order to explain both how it was done and why it should never have been done, I needed to explain the law, and I just, in an hour and a half, an hour and 37 minutes in the last podcast, I just did not have the time to delve into the Prison Litigation Reform Act history, the background, the reasons why these laws existed, and the fact that these laws exist at all, and the laws that were misapplied in my case, which gave rise to Jeremiah Lynch, the magistrate judge at the time, to modify my complaint in order to justify dismissal. So, I talked about how Angela Townsend's boss and CEO of the Forlorned, Dale McGarvey, had worked closely with the now federal judge Dana Christensen while they were both Kalispell attorneys. How he wrote a letter to Christensen telling him that it was Dale's case, basically covertly pointing out that asking for favoritism from Christensen in this case. And I don't know whether it was that letter or it was the fact that I already had a pre-existing issue. I brought a RICO claim against this court, and they had actually dismissed the claim against themselves. Just no judge shall be a party over their own case or their own cause. Yeah, that's another story for another time. And maybe I'll make another podcast on that one just to tell you what I tried when I went through my RICO Act and what happened there. But that's a very long, detailed story as well, and once again I have to be selective in the tangents I go off on, and I go off on far too many. But it was a veiled effort by McGarvey to try to influence Dana Christensen, and whether that was the method and the reasoning, or whether it was the reasoning because I was a U.S. political prisoner who is well known in the state of Montana to be challenging the system. I've published a book, I've published a blog, I've gone out, I've challenged the system with multiple lawsuits. I've made myself a nuisance, and I've made myself very well known that I challenge the corrupt authorities in Montana, and the last thing any court wants to do is give me money. And remember, and I'll remind you again probably multiple times in the course of this video, Angela Townsend raised over $200,000 to make the Forlorned movie. That's $200,000 raised using the title that she stole from me. If I prevailed in this lawsuit, every dime, every penny she made, whether it be through fundraising, sale of merchandising, whatever, would be mine. Which means she would be required to reimburse me for all monies, and that would include the $200,000 she raised to make a movie. The court was not going to give me this, not knowing what I was going to do with it. If I had $200,000 behind me, I'd be hiring marketing campaigns, I'd be hiring advertisements all over the place, I would be campaigning against these people who are in power, and I would be getting a much stronger and louder voice. And they don't want that. They want to silence me. That's why I was stripped from my business assets. That's why I was locked away for 5 years, and why I've been deprived so excessively of liberties that nobody else in the state of Montana has been deprived of. Because they don't want me to have a voice. And that's where these issues come in. So I don't know, there's two factors, and either one or both could be contributing to why this happened, but it did happen, and I'm going to go into the details of what happened and why and how illegal it was, how unjustified it was, and most importantly, how unrestrained the misconduct and illegal, unconstitutional behavior was, and how even the higher-ups in the U.S. District Court of Appeals turned a blind eye to it. There are more factors, obviously, at play. Like how Jeremiah Lynch, of course, changed the facts. He recreated the circumstances to justify his dismissal. He pre-screened and dismissed the complaint under an illegal application of law, specifically 28 U.S.C. Section 1915. And I will define that law because that's the Prison Litigation Reform Act. That's part of it. But first I need to give the background on it, because the Prison Litigation Reform Act is not just something I just breeze over. It's something I have to really talk about in depth. But 18 U.S.C. 1915 is part of a massive overhaul of prison litigation in the United States. It's under the label of the Prison Litigation Reform Act, and this is where I need to fill in some details, because I need to explain not only why this was done, but how this should never have been able to be done. Because this specifically is a law that is only supposed to be applied to people who are incarcerated in prison. Okay? Who are locked up in prison. And I'll read the definition. I'll actually read the law for you, verbatim, to show you that I'm not just making this up. But in order to understand the meat and the potatoes of the law, you need to understand the history of how the law came to be, because it is such a grossly unconstitutional law, and represents another aspect of our country, not just Montana, but our country that is so broken. Between the 1970s and 1990s, the U.S. prisons had seen a host of restraints upon them. So mostly because they entered into settlement agreements with prisoners who brought claims against them, but their costs were going up and their profits were declining. And remember, this was the beginning of the prison for profit system. This was back when the private companies were just starting to get their legs under. By the 1990s, these prison companies were in the Fortune 500 category. That's how wealthy these prison companies were. The greater the influx of prisoners, the more they were aimed at profitizing off of them. With profit the main objective, dignity and civil liberties took a back seat. They cut corners. Of course they cut corners. These companies are no different than a government agency. When you have a chance and you need to lower costs and maximize profits, you cut corners. If you're running a real business, you cut employees, you cut salaries, you cut overhead. When you're running prisons, you give the prisoners less dignity, you take away their civil rights, you take away their freedoms, their liberties that they have in spite of incarceration. You feed them substandard food. You give them substandard protection. You subject them to unreasonable risk of harm. You give them jobs that are dangerous and lethal, and subject them to medical experiments because they're just lab rats. Because that's what they can do. They can sit here and subject prisoners to harm and deprive them of dignity and the most draconian conditions you can imagine, because it costs less. But in the process, it deprives civil liberties. prisoners began to seek remedy from the federal courts. They started going to the courts. Of course, the more inmates that came into the system, the more inmates existed to voice complaints, which in turn created a greater caseload for the courts. And remember, the federal courts didn't get a bump from the prison for profit system. The prosecutors did, the jails and prisons did, the courts really didn't. The judges didn't get extra seats to handle the upswing in caseloads. They didn't get extra staff. They certainly didn't get extra funding. No, those block grants all went to the states. They went to law enforcement, they went to prisons, they went to prosecutors. They didn't go to the courts. So the courts are having all this excessive stuff as a consequence of the prison for profit system. It was a symptom of a disease that was starting to affect a broad range of government. So the bottom line was that there were more inmates and that more voices to complain. More voices that civil liberties and draconian treatment became more vocal. And the more prisons tried to cut corners to increase profits, the more complaints that were made. And of course, the more settlements that were reached to reach this meant the less profit the individual companies were getting. Prisons often settle these rather than get judgments brought against them. I mean, it affects their shareholders. Their shareholders don't want to see lawsuits against their companies. They don't want to see judgments against their companies. So they will often settle out of court in order to minimize their loss. But it's still an extra cost, and it cuts into their profits and their proceeds, and these companies are wanting to make massive amounts of money by warehousing human beings. The end result was that prisons were becoming less profitable. In a prison for profit matrix, they were not making as much money as they wanted to make. It's the old Sony Spider-Man 2 argument. Sony didn't make as much money as they wanted off of Spider-Man 2 because North Korea hacked their system and distributed the movie to the world. So a whole bunch of the world got to see the movie for free. Sony didn't make as much money as they wanted to, and they threw a hissy fit about it. So much so that it did actually something positive come out of that, because of course Spider-Man came over to the Marvel Cinematic Universe, and the rest is history. We now have a wonderful cooperation between Sony and Marvel, and we have a great character in Tom Holland playing Spider-Man, and just wonderful things came out of it. Of course, Andrew Garfield didn't get treated so nicely. The plans for the original Spider-Verse got a little bit side-railed, but it's back on track now. But it's just another example of how big companies, when they don't make as much money, I mean, these prisons were still making money. The prisons were still raking in cash hand over fist. They wanted more. They saw opportunities to make more, and they were frustrated that the prisoners were standing in the way of that. This influx of complaints being filed made it up to Congress. Not because congressional members wanted to be concerned about prisoners and the courts. Of course not. You got to remember, lobbyists are primarily representatives of large companies or industries. The United States, as I recall, is either one of the last or the last major democracy that allows lobbyists. Lobbyists are nothing more than legalized bribes, ladies and gentlemen. They are people from major corporations, major financially wealthy individuals who buy influence in government to get laws passed that make them and their businesses more profitable. And it's no different here. In the United States, legislators are for sale. I mean, there are literally foreign interest groups that come over here as lobbyist groups and buy influence in our Congress. It happens, ladies and gentlemen. We have Japanese people, we have Chinese groups, we have Israeli groups, we have Russian groups who come over here and become lobbyist groups and buy influence in the United States. That's horrific. It's horrific that even is allowed in the United States, much less that foreign countries have influence over the United States of America's laws. But in this particular instance, and again, I should probably do an entire podcast on lobbyists, and I've promised that before, but it's true. The lobbyist system is so broken. But if you have enough money, you can buy any congressman. And that's sadly the truth. Because you offer a large enough contribution to their re-election campaign, they will get a law into the books for you. You want to make import taxes to Japan less? slide some grease into some palms of re-election campaigns and key officials and key control groups that can get the message out to the rest of his constituents, or the rest of his colleagues, I should say, and get the influence out there and get the law passed. And congratulations, now a Japanese company pays less in tariffs and import taxes. All because that congressman is for sale. And private prisons in the 90s had moved into the Fortune 500 companies, and they were on their way into being the Fortune 100 companies. Incredibly profitable, incredible amount of money to throw around, and they did not stay away from Congress. They bought Congress, and they bought an entire bill called the Prison Litigation Reform Act. Money like that buys influence, and it buys influence in government. And with that influence, they bought themselves a new law. Now, propaganda at the time circulated the idea of inmates sitting around filing frivolous lawsuits. The idea that they had so much time on their hands that they decided to make a nuisance of themselves. They started filing lawsuits just to bog the system down. Such stories as I remember hearing, like filing suits because they didn't have cake with dinner, or other ridiculous stories. Their prison material was too scratchy on their skin, something. Now, I'm sure it's human nature to file frivolous actions. I mean, I'm sure there were probably a lot of frivolous claims. Did we remember the coffee being too hot for McDonald's? This happened a few years ago here in the United States. Somebody actually sued McDonald's because they spilled their coffee in their lap and they burned themselves. And their entire defense for this lawsuit was, I mean, everyone says it's coffee. It's supposed to be hot. And I know those countries out there that probably love iced coffee, but in the United States, everyone loves hot coffee. And iced coffee's here too, don't get me wrong. But they love their hot coffee. But the coffee spills in the person's lap. And I burned myself, so I'm going to sue McDonald's over it. And of course, the obvious answer is it's coffee. It's supposed to be hot. And the defense was, well, it's not supposed to be that hot. Of course, as I mentioned before, large companies settle lawsuits. The case was settled out of court. Person got a fairly large settlement, as I recall. And now every single cup of coffee you see says contents are hot. Because they argued that you didn't have a warning label on the cup of coffee that it was hot. I mean, that's the core definition of a frivolous lawsuit, ladies and gentlemen. Oh, I ate an ice cream and I've got brain freeze. I need to sue the ice cream company for pain and suffering. Burned yourself on a hot dog? Sue the hot dog company. There's a whole heck of a lot of frivolous lawsuits out there, ladies and gentlemen, and Congress isn't passing laws to stop them. So why are they focusing on prisoners? Because the companies that are really being affected is not the government. It's the companies. The companies are the ones who are losing money, and therefore they passed the Prison Litigation Reform Act to curb the lawsuits that were cutting into their profits. And like I said, there may have been some frivolous lawsuits, but there's some incredibly vital claims that were made in the 70s through the 90s against deprivation of medical care, starving inmates as punishment, subjecting inmates to deadly environments, putting them to work in sludge and sewage because they're just rats anyway, denying access to courts and appeals. I mean, in effect, treating prisoners like animals and slaves, expendable animals and slaves. But their vital claims as individuals, their human dignity, was cutting into the prison's profits. And with profits at risk, Congress designed a way to cut back inmate claims. And in 1996, Congress passed the Prison Litigation Reform Act. Now, the goal of the Prison Litigation Reform Act was to shut down prison claims against government. That was the core behind it. Under the pretense of reducing judicial burden and lowering unnecessary cost, Congress literally cut prisoners off from the free access to court. They figuratively crippled their ability to make claims against prison abuse. Because prisons, of course, regardless of whether they're private prisons or whether they're federal prisons or state prisons, they are state facilities. They are answerable under state legislation. The prisoners are there under state confinement, state sentence. These are not private companies imprisoning these people. These are the individual states and the federal government imprisoning these people, and simply retaining these private companies under contract to hold them and quote unquote care for them while they're being held. So it's still the government that's being sued. The government is ultimately the one who has to make accountability for this. But, and I cannot say this with enough disdain. In Montana, judges never cared about how inmates were treated. They could care less. I have brought multiple claims against the state of Montana through the federal courts while I was in prison for deliberate infliction of harm, for deprivation of medical care, for cruel and unusual punishments across the board. Again, something else for other podcasts. But let's face it, these judges don't care whether the inmates are deprived. As far as they're concerned, you're in prison, dude, live with it. You're sent there to suffer. But that's not the truth. In fact, the United States Supreme Court has come back on multiple cases and said that prisoners are in prison to be punished, not as punishment. Or sorry, if they're put as punishment, not to be punished. Sorry, I got it backwards. So in other words, their detainment in prison is the punishment. Being deprived of simple human dignities, clean clothes, proper food and health, not being subjected to unreasonable risk, not living with rats or being required to walk around in sewage. These are all things that basic simple human dignity requires that prisons were regularly and routinely not doing anything about because it cost too much. Not that it cost too much, it cut into their profits. And the more deals they had to make with the inmates, the more it cut into those profits. And that's why the Prison Litigation Reform Act came to be. Now, this was a very sweeping legislation in many areas. Among the sweeping changes, not all of them, but amongst them, some of the bigger areas, regardless of the income of the inmate, they were required to repay the full cost of the lawsuit. If they brought a lawsuit against a federal government entity, they were required to repay it. It didn't matter if they had $1 on their account or they had $20,000 on their account. They had to pay it. That 20% would automatically be deducted, and then any time money was put on their books, a lien essentially was placed on their books. So 20% would automatically be deducted to cover the cost of the lawsuit. And remember, these are people who don't earn any money in most cases while they're in there. In prison, inmates are lucky to earn $1 a day for a job. That's a good job in prison. $1, if you could earn $1 a day, you work 4 or 5 hours, you get 20 cents an hour. Boy, that's a good job. I'm not joking. I wish I were, but I'm not joking. In the United States, where minimum wage is in the double digits, I think it's like $15 something now. I've been on disability so long I really have not kept track of what the current minimum wage is. But regardless, when I was in prison, $1.25 was a fantastic, that was the highest wage you could get in working in the normal. Now we did have, like there was a boot factory that made a private contract with the prison. People in the boot factory, they were making a lot of money. Of course, the prison just took more money out of their, now okay, you can afford it, now you can start paying for your room and board. But the idea being, I always had a joke around prison, and I continue to use this as I've gotten out of prison. Someone will ask you how I'm doing, and I'll say, well, another day in the buck and a quarter for somebody else. I could never get the $1.25 an hour jobs because as a sex offender, I was limited in the jobs I could have. In fact, I wasn't even allowed to have a job until I got to the low side, which in Montana State Prison, there's a high side where it's supposedly higher level custody where you go when you first get there. And I had to wait months and months and months and months to get shipped over to the low side, which was lower security, and there I could get a job. But even then, I could not get a job outside the fence. in the outer areas where the money, or in the food preparation areas that move between the two sides, or anything like that, because I was a sex offender, therefore I was limited in the jobs I could have. I was lucky to have, I think I earned like, if I remember right, I earned like 25 cents an hour working in the prison, or working in the prison library. It might have been 50 cents, but it was very low. I didn't earn a lot of money when I was working in the prison. I mean, you just don't. And you're sitting here talking about filing fees of hundreds of dollars to file a claim in a federal court, which means you lose, if I get, let's say I've got that 25-cent model and I earn $2 a day from working 8 hours. $2 a day. I work 5 days a week, I've got $10. That's a whole lot of money. I didn't work 8 hours a day, by the way. I was lucky if I worked 3 or 4. But anyway, let's just say I earn $10 a week. $2 of that's cut off right away. Boom, gone. Because I filed a lawsuit. And that $2 will always be there. So I'm always going to be earning $8 a week. And that $8 has to go to pay for things like, you know, toothpaste, toothbrushes, things that I want. Because despite popular belief, we don't get everything we want in prison. We don't get decent shoes. We don't get decent clothes. We don't get decent anything. You see all these movies and shows where these people have these like really expensive, like, you know, video game systems and everything else in their cells because they have a lot of money. It doesn't work that way. It doesn't work in the Montana State Prison. It didn't work that way. I can't speak for federal systems or other states. It definitely did not work that way in Montana State Prison. And I've been in every single facility in the state. And I can tell you nowhere did that work like that. At best, we had a TV. We could buy a TV on our commissary, pay $100 or so to get a TV. Remember, $10 a week. You're saving up for a while, buying your basic necessities, buying the supplements you need beyond what they give you to eat, because believe me, it's never enough. To buy the basic things you need to basically just be human inside the prison system. To buy stamps, to buy envelopes, paper, these kind of things. Actually, in the prison system of Montana, stamps are actually currency. You buy things from other inmates with stamps because that's your currency. And if you don't have stamps and you don't have a job, you got nothing. I mean, it's pretty sad. You're not allowed to have, you don't get dollar bills flashing around. You don't have, I mean, seeing a dollar bill inside the prison is like a big deal. Seeing a quarter inside the prison is a big deal. But you're talking about people who simply don't have any money to begin with. And they qualify for indigency under any other criteria. But in Montana State Prison and by the federal standards, they don't. If you're a prisoner, you have to repay it, and you're automatically going to be penalized for bringing a lawsuit, regardless of whether you can afford it or not. So, of course, it's really hard on the basic necessities. Then, of course, prisoners had to get permission to appeal from lower court. If they wanted to appeal a decision, if they got a ruling against them from lower court and they wanted to appeal, they had to get permission from the court that just ruled against them. It's called a certificate of appealability. They have to get that court's permission to actually go up to the higher court. Any other U.S. citizen can appeal a decision, an adverse decision against them, but they have to get permission, prisoners do, to appeal a decision, including, as I'm going to talk about in a little bit here, the prescreening requirement. Anytime the lower court decides against them, if they want to appeal that decision to and say that court decision is wrong, it needs to be appealed, they have to get permission. Another sweeping area of the Prison Litigation Reform Act. Pardon me. Prisoners could seek a certificate of appealability from the appellate court, but the appellate court would always go to the lower court to get their feedback and their input. And let's face it, who wants to be second guessed? If I say, no, you can't have that cookie, and that kid goes to your boss and says, hey, he wouldn't give me the cookie. If my boss comes to me and says, do you think you should be able to ask me? Do you think I want to say, yeah, sure, go ahead and make a decision for me. Cut me out of the loop. Of course not. It's human nature. You don't want to be second guessed. You don't want to have your decisions overturned. So you're always going to say, no, I'm not going to give permission for this prisoner to second guess me. I mean, come on. How much common sense is that? Inmates, for the first time, had to exhaust administrative remedy before they could even sue, which meant they had to, if there's a grievance process, which every prison system made sure there was a grievance process after this, they had to exhaust that grievance process before they could ever sue. And many prisons actually instituted such an excessive level of, you have like 10 steps to exhaust it. In Montana State Prison, the steps are 5. It's not just I make a grievance I'm ruled against. 5 steps. You have to go through 5 applications, petitions, and denials. And of course, they'll have anywhere between 15 to 30 days to respond to the complaint. So you're exhausting this remedy. It's going to be like anywhere between 3 to 6 months out before you can finish exhausting your remedy just to go to court. Okay? Now, get this. While this is ongoing, there's no protection for that inmate. None. No one does this give the administration heads up that there's a pending lawsuit. But now they get to sit there and pressure the inmate to dismiss the claim or deny the claim, start denying them rights, put more additional pressure on them, shuffle them between regional institutions. I got shuffled, I call it the regional shuffle. I spent time in every single facility in the state of Montana. Partly, I'm sure, because I was filing claims against the state of Montana, but also because I was a legal advocate. I was called a legal beagle on the inside. I was helping other people with legal work. I became #1 shopping around. I hit every single facility, all 4 facilities in the state of Montana in my 5 years. Well, actually, in my 3 years, because 2 of those years I actually spent in the jail. In 3 years, I hit every single prison in the state of Montana because they did not like me. Because I wouldn't stop making legal claims. I wouldn't stop helping other people make legal claims. Montana doesn't like that. Big surprise. Like I said, I'm not like trying to sit here and take pride in this, but let's face it. I didn't sit back and let people walk all over me. I didn't let people walk over anyone else if I could help it. And corrupt people do not like people who speak out. So when the Prison Litigation Reform Act required inmates to actually exhaust their administrative remedy, it meant that they had to now say, hey, by the way, I want to sue you. Please stop doing what you're doing to me that's making me complain while we go through this administrative. Most times, it simply gets worse. And then like I said, other things like shuffling you around from between different institutions comes onto the table. You start finding out that you lose your job, you lose your income. You find yourself restrained. You get put into a room with somebody who's got a history of having freak-out rage attacks. All these repercussions. You start getting tripped by guards who walk by. Oh, sorry about that. Or the guards stick other inmates on you. You start getting retaliated against because they don't want these complaints, and so they're going to try to discourage you from doing so. And nothing in providing for the administrative remedy process shelters an inmate from doing that. You would think there'd be some kind of a law that would say, well, while they're exhausting administrative remedy, you can't hurt them. That makes common sense, right? No, they get to retaliate all they want. They're inmates. The whole point of the Prison Litigation Reform Act was to take rights away from inmates. It didn't give them more protection. It gave them a lot less protection, and it made them more vulnerable to being hurt while they were trying to bring claims. But another sweeping change of the Prison Litigation Reform Act was in giving courts special powers. And this is where the really big problem comes in. Specifically, courts got to pre-screen prisoner complaints. They could force inmates to either amend or dismiss the claim outright if the court so decided. Specifically, the deprived relief, and this is a direct quote from the Prison Litigation Reform Act. Specifically, the courts were required the courts shall not grant or approve any prospective relief unless the court finds that such relief is narrowly drawn, extends no further than necessary to correct the violation of the federal right, and is the least intrusive means necessary to correct the violation of the federal right. In other words, if the claim was not very narrow and asked for the smallest measure imaginable of relief, courts were forbidden from allowing it to proceed. So if there is a sweeping wrong, the least invasive method, and let's face it, the least invasive method is saying, oh, I'm sorry, won't happen again. Okay, that's good. He got an apology, he's good, it's all done. That literally is really what the law says. The least invasive method to restore the right. I'm sorry, it won't happen again. Okay, he promised he won't do it again. I need to make sure you get how broken this really is. I mean, I don't know how else to say it. It's just broken. The Congress gave the courts, who are supposed to be unbiased, instructions to become parties to the actions and stand up in defense of the government against the inmates. They were required by this law to find legal reasons to act against the inmates and their rights. In effect, a prisoner must fight against both their defendant, whatever agency of government that may be, whether it be the prison, whether it be the Department of Corrections, whatever, and the court itself from day one. In fact, they're fighting the court before they're fighting their actual defendants because the court gets to take first swing at them. That's what pre-screen means. They're required to pre-screen before the other side is even served with a lawsuit. The court is required to pre-screen and determine whether to dismiss the case outright. Remember, even if an inmate somehow survives the pre-screening process, the court is now prejudiced against them because it's already taken an aggressive stance against the inmate, and that's not going to be forgotten down the line. They're already aggressors against the inmate. The inmate does not have a friend in the court. Where is there ever a possibility of a fair hearing or an impartial administration of justice? When the court is ordered by the law to take a stand against the litigant before the defendant in the case is even notified of the lawsuit. Just to be clear, the U.S. Constitution forbids this. Absolutely forbids this. The courts are set up to be neutral arbitrators between disputing parties. They are not supposed to take sides. They are not supposed to show partiality to one or the other. But the Prison Litigation Reform Act weaponized the courts against inmates. It created a nigh invincible obstruction to inmates' rights to due process and access to court. Worse, the 14th Amendment to the United States Constitution forbids this. Forbids this. The 14th Amendment specifically requires equal treatment under the law. To treat any group or class differently is known as invidious discrimination, or more precisely, unfair and unequal discrimination. When you take one group and treat them differently than another group under the law, it is invidious discrimination, and the 14th Amendment to the United States Constitution forbids it. So when Congress decided that inmates did not deserve equal access to court, by virtue of their imprisonment alone, this law created invidious discrimination across the board. No other American is supposed to be required. Now, I'm going to get into that, why that's broken here in Montana. But no other American is required under law to further impoverish themselves to pursue a lawsuit. If they can't afford the filing fee, the fee is waived. They don't have to reimburse it later on. If they have $2, they don't lose 40 cents. There's no other American is required to get permission to appeal an adverse decision. No other American has to have their claims pre-screened. But wait, this is actually what the U.S. District Court of Montana is doing to poor litigants. Any individual who seeks a waiver of fees in the U.S. District Court of Montana is subjected to this pre-screening and this Prison Litigation Reform Act. I'm not joking. It absolutely is. Just to be clear, the law is called 28 U.S.C. Section 1915, and that applies to prisoners. The language of the law is very specific, and I'll read that to you in just a moment. And 1915A, 28 U.S.C. Section 1915A, gives courts the ability to pre-screen prisoner complaints brought against government entities. That's important. With none of the prison conditions in the normal area. The normal area of what's called informa pauperis in impoverished form is Federal Rules of Appellate Procedure, Rule 24, provides for other informa pauperis filings. Federal Rules of Civil Procedure, same thing. No prisoner, it says anyone who cannot afford can have their fees waived. No requirement to be reimbursed from their accounts, no pre-screening, no nothing. Section 1915 specifically applies to prisoners, and I'm going to read that to you right now. 28 U.S.C. Section 1915 reads, subject to subsection B, any court of the United States may authorize the commencement, prosecution, or defense of any suit, action, or proceeding, civil or criminal, or appeal therein, without prepayment of fees or security therefore, by a person who submits an affidavit that includes a statement of all assets such prisoner possesses, that the person is unable to pay such fees or give security therefore. Skipping a little bit, Section 2, a prisoner seeking to bring a civil action or appeal a judgment in a civil action or proceeding without prepayment of fees or security therefore, in addition to the filing affidavit under paragraph 1, shall submit a certified copy of the trust fund account statement or institutional equivalent for the prisoner for the 6-month period immediately preceding the filing of the complaint or notice of appeal obtained from the appropriate official of each prison at which the prisoner is or was confined. An appeal may not be taken in the form of pauperis, so the trial court certifies in writing that it is not taken in good faith. Now, going to Section B. Notwithstanding Section A, if a prisoner brings a civil action or files an appeal in the form of pauperis, the prisoner shall be required to pay the full amount of the filing fee. The court shall assess and, when funds exist, collect as a partial payment of any court fees required by law an initial partial fee of 20% of the greater of the average monthly deposits of the prisoner's accounts, or the average monthly balance of the prisoner's account for the 6-month period immediately preceding the filing of the complaint or notice of appeal. After payment, paragraph 2, after payment of the initial partial filing fee, the prisoner shall be required to make monthly payments of 20% of the preceding month's income credited to the prisoner's account. The agency having custody of the prisoner shall forward payments from the prisoner's account to the clerk of court each time the amount in the account exceeds $10 until the filing fees are paid. In no event shall the filing fee collected exceed the amount of fees permitted by statute. Every aspect of this law is prisoner, 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 prisoner. This applies to prisoners. Now, Section 1915A. Screening. The court shall review before docketing, if feasible, or in any event, as soon as practicable after docketing, a complaint in a civil action in which a prisoner seeks redress from a government entity or officer or employee of a government entity. Grounds for dismissal. On review, the court shall identify cognizable claims or dismiss the complaint or any portion of the complaint if the complaint, 1, is frivolous, malicious, or fails to state a claim upon which relief may be granted, solely at the discretion of the court, of course, or seeks monetary relief from a defendant who is immune from such relief. This is really important. Pay attention to this part. Definition. As used in this section, the term prisoner means any person incarcerated or detained in any facility who is accused of, convicted of, sentenced for, or adjudicated delinquent for violations of criminal law or terms and conditions of parole, probation, pretrial release, or diversionary program. Now, why this definition is important. Pardon me. This applies to pre-conviction detainees as well. This is not a right lost by virtue of conviction. It's just because you are detained. And remember, in Kalispell, you can be detained a year or longer waiting for trial, which means if you try to bring a claim during that period of time, you're still held to the Prison Litigation Reform Act. If you file a habeas corpus, you're still subject to the Prison Litigation Reform Act. If you file any civil action against any entity, this is how they interpret it. It doesn't matter if this is not a loss of right by virtue of conviction. This is a loss of right by virtue of incarceration. Also, take note, the screening rule is only against claims against governments or government employees. If a prisoner wants to sue their sister, there's no lawful pre-screening. Once again, of course, the Prison Litigation Reform Act is designed to curb claims against government infringements upon civil liberties. It's not there to stop and lessen the load. If someone wants to sue McDonald's because they're from inside prison because their ad logo is offensive and derogatory, they can do so under the Prison Litigation Reform Act to their heart's content. Just don't bring lawsuits against us. Don't bring lawsuits against the government, because then we're going to sit there and pre-screen it, and we're going to decide if we want to totally even allow the claim to go through. Now, the problem is, as I've mentioned, the U.S. District Court of Montana applies Section 1915, 28 U.S.C., Section 1915, and 1958, 15A to all poor litigants. Anybody who files for informal pauper status, anyone who files a waiver of fees. That's right. This gross excess of law, in gross excess of law, the U.S. District Court of Montana applies a prison statute impaneled and empowered by the Prison Litigation Reform Act against people by virtue of their poverty, by virtue of the fact they cannot afford filing fees. They will actually say in their summary that 1915 requires them to pre-screen. No, it doesn't. I've just read it to you, ladies and gentlemen. I just read the law to you. It does not say anyone who applies for informal pauper status is screened. It says prisoners. And then only prisoners who bring lawsuits against the government. And then specifically, if you are detained. That's the definition of prisoner under the law. It's right there. I read it to you. You can look it up for yourself. If you don't believe what I read to you, if you think I made that up, look it up. 28 United States Code. That's what USC stands for. Section 1915 and Section 1915A. No parentheses, just 1915A. Look it up if you don't believe I read you verbatim what the law says. Because that's what it says. Yet the U.S. District Court of Montana routinely screens anybody that files informal paupers. If you cannot afford your filing fee, you will be pre-screened. Not because they have the right to do it, but because they are screening out and shutting down anybody who's not wealthy in the state of Montana. If you're wealthy, if you have money, they don't. They'll give you your day in court. But they won't if you're poor. And they'll do everything in their power to shut you down if you're poor. Okay? Now, the problem here is this has been the way the U.S. District Court has suppressed every major claim I have brought. When I brought the RICO claim, they used this pre-screening requirement to shut down every single defendant but one. Now mind you, RICO is a Racketeering Influence Corrupt Organization Act. It requires a coordination between other parties in a chain conspiracy in order to have a degree of success. When you bring it down to one defendant, it makes it impossible to succeed. And most notably, Jeremiah Lynch and Donald Malloy were defendants in that RICO suit, and they used the pre-screening process to dismiss themselves. That's right. They dismissed themselves from that lawsuit. So, no man shall be the judge of their own cause. Sound familiar? I've brought it up a lot of times in recent months as I've talked about how the Montana Supreme Court has been shutting down the Montana legislature's subpoena powers over the Montana Supreme Court. The Montana legislature wants to subpoena the records of the Montana Supreme Court. The Montana Supreme Court says the rule issues an order saying you can't do that against us. They cannot be judges over their own cause. Pretty standard common sense, honestly, but it is a legal standard. Montana ignores it. Of course they ignore it. But when they filed the trademark claim, it gave Jeremiah Lynch the ability to pre-screen and dismiss the case, and Dana Christensen the ability to back it up without ever requiring Angela Townsend to file a single response because she's not a part of the action, because they went through the pre-screening process, which was required before she could even be served. The court had to satisfy and pre-screen it. But to make matters worse, the court went 2 steps further. Both illegal, both violations of law. Jeremiah Lynch changed my pleadings in order to justify dismissing it. And then when I appealed it, and the court went back to the lower court for a certificate of appealability to see whether the lower court approved it, Dana Christensen came up with another reason entirely, claiming that I had not actually earned any money off the trademark, and therefore I could not claim it in the use in commerce. That's not the law, ladies and gentlemen. I'm going to read the law to you. Once again, let's take a brief look at the law. In this case, the Lanham Act, also known as the Trademark Act of 1946. In this case, the law provided for 2 methods of securing trademark rights. Registration, which preserved the rights of businesses who are in development. Like if I wanted to, create a business called Floral Decay, and I like the name Floral Decay, but it's going to take me a couple of years to get it down. Meanwhile, there could be, industrial sabotage. Somebody else can come up with the idea, somebody else can come up with the name. So I'm going to preserve it while my company's in development and getting ready to be marketed. So I file a registration. It preserves my name, it preserves my right, and that way I've got the entitlement to the type, the name, Floral Decay. And by the way, I'm not claiming it. If anybody wants the name Floral Decay, write me, share it with me. I'd love to find out what you come up with for that title. It's just a wonderful title. I'd just love to see what you do with it. But anyway, that said, the idea being, if you have one area of registration, but the second area is called use in commerce. Now, there are 2 aspects to use of commerce, and one does require that proceeds be derived. But there's a second criteria of use in commerce that reads as follows. And specifically, this is from 15 U.S.C. section 1127, if you want to look it up. On services when it is used, or replying to what use in commerce defines, there's one definition and there's the second definition. This is the second definition. On services when it is used or displayed in the sale or advertising of services, and the services are rendered in commerce, or the services are rendered in more than one state and in the United States and a foreign country, and the person rendering the services engaged in commerce in connection with the services. I posted the name of the Forlorned on my blog, advertising the upcoming release of this book, that it was my title, that Angela Townsend had permission to use it, and that she was going to give me credit of it. Mine was the first presentation in commerce. It was advertising a forthcoming book and title. I then proceeded to actively be engaged in promoting the book and the movie that followed for a year and a half. But my website, my protestations, my demonstration, and my advertising was the first use in commerce and the first declared ownership of the Forlorned. That's the truth. Now, that's what Christensen claims, that just simply that use is not enough. I have to make money at it. That's not what the law says. I just read the law to you. Okay. In my suit, I very specifically brought, and I'm going to quote a brief summary from the appeal, because otherwise I have to go back to the actual complaint, and it's much broader. But I just read you, or told you what happened, but I'm going to read it to you in a breakdown format directly from my appeal. Appellee Townsend, that's Angela Townsend, requested assistance from appellant, that was me, to rebrand her former novel. Appellant created the mark, the Forlorned, for said appellee's conditional use. Appellant assisted said appellee in restoring Fears of a Fisherman to an editable format for said appellee. That was the book, the original book that Angela Townsend only had a PDF version of, that I helped restore to something she could edit. An appellant made the first commercial use of the mark on his internet website on the same day as said appellee obtained the cover art. She got the cover art, she shared it with me, I posted it on my website, not with the intention of preserving or right here, I was just, hey, look how cool this is. She's got this book coming out, ladies and gentlemen, and she's going to use the title I created, and she's agreed to let her use it. She's agreed to give me the credit for it, da, 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 da. It wasn't an attempt at that time to actually set my feet in the ground and say, okay, I'm just going to preserve my rights. It just happened to be that way, that mine was the first use, because I was so excited about this that I wanted to advertise it and promote it. And I promoted it, and she never disputed it. For a year and a half, she never disputed it. She made all kinds of filings all over the place for her other books. And she has a lot of other books. She didn't do anything for the Forlorned. She never filed a trademark, she never filed anything, because she knew it wasn't hers. Look, you still be looking at her pattern of behavior with every one of her books. And if you look at the book The Forlorned, by the way, now I can't speak to it because I haven't read it in recent years, she may have edited it. But if you go back to a first print edition of the book, and it may be true even today, the word The Forlorned does not appear in her book. Forlorned is nowhere in Fears of the Fisherman. It is nowhere in the book retitled and rebranded The Forlorned except the cover page, the title. She did not come up with the word. It is not part of the story. It is something I created in addition to the book, in addition to the content inside. That was my creation. It was not part of her work. It never was. Which is why it's so significant that what Lynch claimed, now when I said that Lynch claimed to change the details, when he summarized his objection and recommended dismissal of the claim, he said that my claim stated that I restored an image for Angela that had the title already in it, and that my restoring the title, or restoring the image, did not grant me a trademark claim. Well, of course it wouldn't. If she created the image in the past and I restored it or recovered it, that would not give me claim to the title. Of course it wouldn't. That would not be a legitimate claim. But that's not what happened. I created the title at the end of July. She submitted it for a book cover for advertising purposes the first part of August. My complaint is very clear on that point. Lynch deliberately changed the details because as they were presented by me, it was a valid trademark claim. And he didn't want to give me a valid trademark claim worth $200,000. So he changed the details. And when I filed an objection to his recommendations, Dana Christensen upheld his interpretation. When I filed the appellate court, the appellate court upheld his. I mean, it was so blatantly and flagrantly obvious. You put the two side by side. You put my complaint side by side with his recommendations. They are not the same summary, and I pointed it out. It wasn't like I ignored it. I pointed it out. I pointed it out in my objection. I pointed it out in my appeal. I pointed it out when I tried to file for the U.S. Supreme Court writ of certiorari, which, by the way, I was not denied on virtue of merit. The U.S. Supreme Court accepts less than 8% of cases filed with them every year. Mine fell into the 92% that wasn't accepted. In fact, the notice I received from the court, every time I file something with the U.S. Supreme Court and it's been denied, it says, this dismissal is not a judgment upon the merits of the claim. Because they're not even looking at the merits of the claim. They're making no ruling or determination, no precedent, no nothing. They're just saying, we don't want to look at that one. That's certainly not, once again, a broken system, but that's the way it is. Lynch insisted that the case was dismissible because of his misrepresented summary. Christensen later, in his defense of the certificate of appealability, which again should not be applied to an individual who's not in prison, but he claimed the reason why is because they didn't make profit. And again, the Lanham Act has two criteria, one of which does require making profit, the other of which requires advertising and commerce for future sales. It was a maintained and supported marketing because I was involved with it for a year and a half. I I created it. I first mentioned it in Commerce, and then I went around and helped promote it because it was my shared project. It was my title, her book, her story, but it was my title, my trademark. And she stole it. The whole idea here is that in the end, the Court of Appeals upheld the district court's ruling and found the lower court rulings proper. Just as the Supreme Court decided not to issue it. At every level, what I said was ignored and disregarded. When I made the original claim, it was changed because the original claim could not be disputed. Angela Townsend had broken the law. Angela Townsend would have owed me $200,000. The only way to prevent that claim from going through was to change the details. And that is called fraud on the court, ladies and gentlemen. It's illegal, and the district court should have been held in check. Christensen should have come in and said, told Lynch that he did wrong. But no, Christensen said, no, he did a good job. The district court of appeals came down, or the U.S. Court of Appeals came down for the Ninth Circuit and upheld the ruling. And the U.S. Supreme Court wouldn't even hear it. This has never been about the merits of the case. If you actually look at the merits of the case, and I have presented volumes of evidence in the last podcast, in the last episode, showing my claim. I am giving you this case right here. And I'll put the case number in the text of this so you can actually reference it yourself. You can go to the Court of Appeals, you can go to the U.S. Court of Appeals, you can go to the U.S. District Court, and you go to the U.S. Supreme Court. And you can look at all these, and you can see that everything I'm saying is true. Look at my original complaint. Look at the summary of my original complaint. Read it. In fact, if you follow the links in my last podcast episode, you've already read my complaint because I posted it online. I posted my appeal online. I post information online, ladies and gentlemen. I don't hide behind these little manipulations. I'm all about the truth, only the truth. And whenever I can, I'm going to support it with records. And when I can't, I'm going to swear from my knowledge. I'm never going to lie to you. I'm never going to tell you something that's not true. I'm never going to mislead you. I don't have ulterior motives. My motives are the truth. Those are my ulterior motives. And you sit here and you have someone like Angela Townsend try to claim that the U.S. Supreme Court ruled against me. They did not rule. They didn't even accept the case. When she sits here and says that it's her valid trademark, only because she insisted I not file the trademark so it wouldn't influence her ability to sell the book to publishers. And yet for a year and a half, and she only filed it the day after I filed a cease and desist on her because she declared she was going to take it for herself. I've got all those documents. Everything I've got, everything I've seen is backed up. She doesn't have a valid... If she created this title clear back in 2014 like she claims, why didn't she file a registration back then? Because it wasn't hers and she knew it wasn't hers. And it wasn't until she started actually making money at this and she realized, holy cow, I may have to pay Ron money. I may actually get... Now mind you, I never asked her money. This is her greed talking. All I ever asked for was credit. I wanted to expand my brand, what's called brand recognition. The more things my brand is attached with, and in this case the brand being my name as an author and my creations, the more things my name is attached to, the greater my brand is. The greater my brand recognition is, the more visible I am and the more sales I make myself. I wasn't trying to make money off the Forlorn. It never was. I just wanted recognition. She saw money. She saw dollar signs. And she was afraid that she would, if she did something, and again, this is speculation. This isn't me. I really can't testify to her state of mind, but this is speculation. I honestly believe she only did this because she thought that someday I might come after her for money. I wasn't going to. I never would have. But this is how she thinks. Remember when I go back to that axiom of psychology? We judge other people by our own moral compass, by our own ethics. If we steal, we assume everyone else steals. If we would go after and chase somebody for money in lawsuits and be litigious, we assume everybody else is as well. And that's Angela Townsend, in my opinion. Again, I can't testify to her true state of mind, but under the circumstances, it's the only thing that makes sense. She saw dollar signs. She saw dollar signs and she said, they could have bought, I mean, they had $200,000. They could have come to me and tried to buy it off of me and say, hey, we want to buy the Forlorned. We don't want, or we'll have an end user agreement, we'll have a silent partner agreement where you remain off the credits, but we'll pay you royalties. They could have done any number of things other than just outright try to steal it. But that's what they chose to do. Because they were greedy. And greed is the only thing in my mind that explains this. So when you sit here and you look at the situation as a whole, and the fact that I didn't talk about the actual details of the lawsuit last time, I hope you understand why, because there's so much involved. You had to understand what the Prison Litigation Reform Act was, what Section 1915 was, 1915A was, and you needed to know why those didn't really apply. So when you hear this story, try to understand. I did not roll over on this. I fought in every way that I could. But the courts defended the criminal misconduct of Angela Townsend. Whether because it was a favor that Dale McGarvey called in, or whether it was because of an extended deprivation of my rights because I was a political prisoner, and they didn't want me to have $200,000 to fight back against that. And remember, if I have money, they lose the ability to pre-screen my cases. Okay, that's another factor to take into consideration here. If they can't use this in form of pauperous argument, and I have money to afford my cases, they can't pre-screen anymore. That's another huge problem. I could actually bring a suit against them again, and they could not pre-screen because it's not under a form of pauperous. It's not a pre-screening. Mind you, what they're doing in the beginning is already illegal. They're applying a standard that applies to prisoners to anyone who's poor. But it's still an informal pauperous ruling because wealthy prisoners can still file without being pre-screened. Only the poor ones are shut down. And they extend that poor criteria to the rest of the state in Montana. Like I said, remember, they raised $200,000 to make this movie from my title. If I prevailed, that's $200,000 in my pocket. Now, mind you, they spent it. It doesn't mean I can't go reclaim it. It doesn't mean I'm not going to have some recoup, or they might not have some cash somewhere or something. They have a project being operated under a title that I owned. Under my original summary, before it was changed by Jeremiah Lynch, my claim was valid. They knew it was valid. That's why Lynch had to change it, because he could not let the original summary stand, because he could not deny it under the original summary. It was a valid claim. I made the first use in commerce. It was my trademark. I created it. She stole it illicitly. I had documents. If it had gone to trial, I had email. You've seen all my evidence, ladies and gentlemen. Well, you've seen glimpses of it. All that would have been in a trial. I never got a chance to go to trial. I never had my day in court. Because Lynch changed the details and used it as an excuse and created a fictional narrative. And that fictional narrative was used to shut down my case. And I fought. I objected to it. To Dana Christensen upheld it. I objected to it to the state or the U.S. District Court, U.S. Court of Appeals. They upheld the decision. The U.S. Supreme Court case wouldn't even pick it up. If Townsend loses this, if Townsend loses this claim, all that ill-gotten gain that she has is gone, and it comes to me. And no corrupt government in the world wants a political prisoner with $200,000 in their pocket, or even a portion of it. The more money I have, the less control they have over me. And if their whole objective is to keep control over me, to make sure I don't have a voice, they're sure as heck not going to give me the rights and claim to $200,000. Thank you for listening. As always, once again, please take the time to like and subscribe. If you're watching this on another platform, whatever the equivalent is, whether it be thumbs up, thumbs down, whatever the criteria, please show your favor for the efforts and the content of this video. Share it. Share it on social media, Twitter, Facebook, whatever avenue you can. Get the information out. The more information we get out, the more people that listen to this, the better chances we have of affecting change. And as always, make sure you watch for the text portion of this video. If it's not attached to the video, for some reason you've seen this video without the text attached, please feel free to visit me on YouTube, look for the Great Montana Conspiracy Podcast, or visit me on monspiracy.podbean.com where this podcast originates. As always, I hope everyone out there is safe, and whenever possible, please be free. Thank you.